That's true.
Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell,
Present.
Lamatia, Menendez, Middleton, Parker, Perry, Schwartner, Zaffarini, Paxton, Hughes.
Here. Well, good morning. At this time, the chair lays out Senate Bill 997 and recognizes its author, Senator West, to explain the measure. Welcome, Senator West.
Thank you very much, Mr. Chairman and members. This bill is, all of us, for the most part, remember Kobe Bryant and his daughter, Gianna. And we know that there was some scrupulous activity, whether it was intentional or just omissions, where pictures were taken of their remains and, frankly, broadcast, laid out, sold to persons, and these pictures were taken by EMS employees. And so that necessitated me in thinking that that type of activity should be prohibited here in the state of Texas also. We have a committee substitute.
The chair lays out the committee substitute and recognizes Senator West to explain the substitute.
And Mr. Chairman and members, what the committee substitute does, it's a collaboration with medical examiners and other employees here in the state of Texas that deals with these types of incidents. And what we initially had in the original bill, we made it a state jail felony to publish pictures of human remains. And so we worked with them to make certain that it just didn't apply to EMS workers, but it applied to all government employees. If indeed there are photographs of human remains that were taken in the course of employment, then it would prohibit the selling of those pictures. It would create an affirmative defense, though, that the pictures were published in the normal course of employment. But if they're not, then this law would prohibit it. We also took out the state jail felony and made it a civil penalty up to $10,000. We also took out the provision of making the government agency, the local government responsible, liable. We took that out also. I think that this is a good collaboration between those persons that normally deal with these types of issues and having policy in place that prohibits the taking of these photographs, the selling of these photographs, publishing of these photographs by persons in the normal course of business.
I thank you, Senator West. Senator Birdwell.
Thank you, Mr. Chairman. Thank you, Senator West. With your committee sub, which I don't have in front of me, does it?
I can barely hear you, Brian.
I don't have the committee sub in front of me, but on page 2, in the original bill, you mentioned jointly and severably. Would you explain what the committee sub did differently with that? Sure.
We took that out. If you look at.
Okay. And then also you have it as it's a defense prosecution for an official law enforcement or medical purpose. Would that be constrained to the courtroom or the coroner's office?
I can barely hear you.
I'm sorry. Would the official purpose of a law enforcement or medical purpose be for the coroner's office or in the courtroom if it related to a prosecution of a criminal act? Would those be I'm assuming those would be self-evident. What other elements would be, what other actions would be for a governmental purpose or for an official purpose?
I'm not understanding the question, Brian.
What I'm trying to Senator, I support your bill, but what I'm trying to determine is what would be an official law enforcement or medical purpose. In my mind, something in the courtroom would be a law enforcement purpose. Something in the coroner's office would be a medical purpose. Are there any other purposes in your mind that would meet that definition of an official law enforcement or medical purpose?
And not in my mind. I think that if you, let me go back to my prosecutor's days. You know, we used to have pictures, but you didn't have cameras, you know, video cameras and all that stuff. And so we would use, as an example, if I tried a murder case and we had pictures of the remains, we called it res gestae of the offense, of the criminal offense. And so we'd introduce it for a particular purpose. And so to the extent that someone is using them in a court of law, okay, then that's an official purpose. If a medical examiner is using it for research or something like that, I think that's an official purpose also.
Right. The reason I ask is that while I'm not deceased, but I had to give my consent for my surgeons to use many of the pictures that they took in the operating room for medical training purposes. Would such an exemption exist if the family of the deceased gave permission?
Absolutely.
For that okay.
Yes, absolutely.
Okay. All right. Thank you, Senator. Thank you, Mr. Chairman.
Senator, any other questions for the author? Here. Thanks, Senator West.
Thank you, sir.
No witness has registered to testify on, for, or against. I'll ask if there's anyone present wishing to testify on, for, or against Senate Bill 997. Public testimony is open. Anyone wishing to testify on, for, or against? Seeing none, public testimony is closed, and the bill is left pending at this time. The chair now lays out Senate Bill 1617, and recognizes its author, Senator Johnson, to explain the measure.
Thank you, Mr. Chairman and members present and unpresent. Senate Bill 1617 does something pretty fundamental for the Office of Attorney General that we generally have in the private sector. In the private sector, when parties are litigating and they want to settle, those communications between the parties are generally confidential, and that allows for parties to actually reach a settlement outside of the fear that they're going to jeopardize their position in the lawsuit. It's really essential to being able to settle complex disputes. The Attorney General's office doesn't have that ability because any of those settlement communications presently, due to probably some bad drafting, are subject to a public information request. This bill essentially defines settlement communications as privileged information that is not subject to disclosure under Chapter 552 of the Government Code. This committee's substitute cleans it up a bit to alleviate some concerns. It ensures that if you have a document that is otherwise discoverable, you can't simply attach it to a settlement communication and thereby render it non-discoverable or non-subject to the Public Information Act. If it's discoverable, if it's subject to the PIA, that status doesn't change when you attach it to an otherwise privileged communication. And finally, that information becomes subject to disclosure 90 days after the cessation of the settlement negotiations. So this stuff isn't shielded forever, or if the case is closed or otherwise considered complete. Making these communications privileged will allow the Attorney General's office to reach settlements that are in the best interest of Texans. They're presently impaired in those efforts, and this bill seeks to fix that. Thank you, Mr. Chairman, members.
Thanks, Senator. Members, any questions for the author?
And we do have a witness here from the Office of Attorney General if you have specific questions for them.
Members, do we need the resource witness? Senator, do you need the resource witness?
I do not.
Very well. No one has registered to testify on, for, or against, but we're going to open public testimony at this time. Public testimony is open. Is anyone present wishing to testify on, for, or against Senate Bill 1617? Seeing none, public testimony is closed, and the bill is left pending at this time. The chair now lays out Senate Bill 1044, and recognizes its author, Senator Johnson, to explain the measure.
Thank you, Mr. Chairman and members. Senate Bill 1044 builds on some good work done previously in this chamber regarding deep fake advertising. Technology is racing ahead with the advance of Photoshop and artificial intelligence technology. It's easier than ever to create a manufactured but very realistic image of a person that can be used to imitate an individual running for office, to mislead voters during an election, make it look like somebody is saying something they didn't say, like they're doing something they didn't do, or actually alter their image to appear like something other than what they are for the purpose of altering the outcome in elections. These are hyper-realistic images. They can and do trick voters into believing that a particular political candidate said or did something they didn't say or do. Currently, a deep fake video under existing law, if it's made in the 30 days before an election, is a Class A misdemeanor. Senate Bill 1044 would create a Class B misdemeanor offense in addition for anybody who, with the intent to deceive and to influence the result of an election, creates an altered image or distributes the altered image during the 90 days before the election. It is essential, if we're going to preserve our democratic process, that we not allow voters to be tricked by this kind of digital manipulation of images, and this bill seeks to combat that so we can preserve the integrity of our elections. You know, it's interesting, Chairman, members, I've talked to people, elected officials in both parties who have been frustrated by this kind of nefarious tactic employed in elections, and I think it's time we put a stop to it.
Thank you, Senator. Senator Birdwell.
Thank you, Mr. Chairman. Senator Johnson, on the bill, did you give any consideration to the timing of when such an act or the altered image arrives in the public view? Let me give you an example. Something that gets put out right at early voting, something that happens just before Election Day. If you remember what happened to President Bush in 2000, now it wasn't a deep fake video as you described, but would there be elements of maliciousness related to the timing of when such a video appeared?
Presently,
you and I both know that a lie is halfway around the world before the truth gets its boots on.
Right, and presently the bill does not have levels accounting for more or less malicious behavior based on how close it is, but we do have a cutoff so that we're not talking about something that's just randomly floating out there with the possibility of affecting an election someday. It's got to be within 90 days of the election, so that we.
I guess what I'm trying to drive to is you could have a circumstance you could find is you could have a non-campaign actor put something out.
Oh, a third party?
At a critical time and place that by the time the responding campaign responds, that based upon its timing, the election could occur. The Secretary of State now has some period of time to certify the election. If it's a Secretary of State certifiable election, to certify that election, and you've now got, instead of sequential actions, you've now got overlaid actions where you've got a clock on the Secretary of State, clock on the campaigns, and who's to say which votes were influenced by that deep fake video, and then making a determination to certify an election, and the only cost to the third party is a Class B misdemeanor and a $2,000 fine.
Yeah,
maybe the wrong person's in office. So while I understand the intent of what you're driving at here, if something like this happens in July for a November election, that sequential action can be substantively addressed. But if it's close to Election Day with the clock on the Secretary of State, that is a tougher nut to crack.
I agree, Senator Birdwell, and I think the problem you're raising is one I actually have a great deal of concern about myself. This bill, I'll tell you what the bill doesn't do. It doesn't make that problem worse. If somebody does somehow affect an election, whether it's through deepfake videos, social media lies, whatever, it's problematic. This bill doesn't address the question of how much damage was done in the election process. Should we certify this election or not? That's a whole other sticky question. What the bill's more modest than that, frankly. It does provide a mechanism, a mere Class A or Class B misdemeanor. I can understand some people wanting it to be harsher, some people worried that we're doing it at all. I want to at least have a mechanism in place where we can discourage this kind of activity. If they do it anyway, we've got another problem that's not addressed in this bill.
Yeah, the First Amendment, the freedom to lie, because we've had that done to us, I'm sure. But that is a protected level of speech, using my image against my will to portray something that has not in fact occurred. That is a lie using my image. So there's a patent or a copyright to my image violation, even though lying is the same, whether it's with my image or not. I'm just thinking through the second and third or fourth order of effects of the bill.
And we have to
figure out.
But if someone wants to challenge us on First Amendment grounds, I say bring it.
Right, but it's going to beg other questions, and that's why I was asking them, because I'm asking the questions not because I have the answers to them, but I wanted to see if you had thought through it, because many of the answers may very well be subjective.
And I'm aware of those questions being out there, more aware of it as a result of this conversation, and maybe that's something we continue to look at outside of this bill. I don't think I can address those second, third, fourth order issues through this bill, but I acknowledge they're a real concern.
Yeah. Okay. Thank you, Senator. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you, Senator. Senator Paxton.
Thank you, Mr. Chairman. Thanks for bringing forth this bill. I think it addresses an important thing that really does go straight at the heart of the integrity of an election, right? When people are making decisions based on false information. And it's very difficult, even for very discerning, savvy people, to distinguish, right? So my question is, the bill says if the image or video or whatever, did I understand correctly, if it's created within 90 days?
Well, there's two sections.
Okay.
One of them refers to the creation, and this actually is a little bit complex. If we look at page 2, paragraph E, paragraph D2, it's let me get to my ors and ands here. Yeah, an altered image, and this is the new part of the statute. It's an image that has been manipulated to change the physical appearance of an individual or depicting an individual performing an action that did not occur. And I'm sorry, is that the wrong paragraph?
Well, and I might just.
I'm sorry.
That's okay. Let me
yes,
kind of
yes,
complete the question.
Create.
Yeah, let me just kind of finish the thought of the real center of my question, which is, let's say that it's created 91 days out, but then distributed within the 90 days, right? That's kind of what I'm getting at.
Well, and actually the bill does address that in paragraph D. It's if they publish or distribute within 90 days.
Okay.
The 90 days isn't the creation date.
As I was listening to the bill layout, I just had.
And they might be watching this and create one right now.
Yes.
But the 90 days when they use it.
They'll put my head on you and your head on me.
Yeah.
I'll say, wow, that's weird.
We've both seen that stuff in elections.
All right, thank you. I appreciate that.
Thank you.
So it addresses not only the creation timeline, but also when it's distributed.
And the intention.
Intentionally distributed, correct.
Right.
Thank you.
And it doesn't, it exempts satire, right? If no one would take this seriously in the first place, if they put my head on you and your head on me, they're probably not going to be in trouble here. It's the other things that we all are aware of where they deliberately manipulate images. It could be spoken, it could be visual. We've all seen it.
Thank you, Senator. Members, any other questions for the author? Thanks, Senator.
Thank you, Mr. Chairman and members.
We do have as a resource James Tinley from the General Counsel of the Ethics Commission. Anybody have questions for our resource witness? Very good. We'll open public testimony and ask if there's anyone present wishing to testify on, for, or against Senate Bill 1044. Seeing none, public testimony is closed. Bill's left pending at this time. Thank you, Senator. Good to have you. The chair now lays out Senate Bill 2120-2120 and recognizes its author, Senator Zaffarini, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 2120, co-authored by Senator Sparks, relates to the establishment of a family protection representation program within the Texas Indigent Defense Council. Members, this bill was requested by the Texas Judicial Council as a result of Senator Colcourt's 2019 bill, which directed the council to develop a statewide plan to address the lack of statewide data collection for court-appointed legal representation of families. The Texas Judicial Council asked the Texas Indigent Defense Commission with its data collection and charged them with a reporting. Their findings indicated substantial variation in court-ordered legal representation in CPS cases. Specifically, they reported wide variation in compensation and structures for attorneys. And to address this concern, the Texas Judicial Council requested the legislature to establish a family protection legal representation program within the TIDC. This bill would ensure indigent parents and children receive competent legal representation when involved in suits filed by the Department of Family and Protective Services. Generally, it would ensure legal representation and services to indigent parents or children named in a suit filed by DFPS, direct the Indigent Commission to create qualification standards for attorneys representing persons in those proceedings, direct counties to prepare a yearly report, and require the Indigent Defense Commission to offer administrative support such as trainings, implementation, and data support. I do have a lot of details if you would like them, Mr. Chairman. If not, that's what it does generally.
Thank you, Senator. Members, any questions for the author?
There's a resource witness. She's a resource witness. No, if you have questions. If he has questions.
Senators, we have a couple of witnesses here as resources. Do we need to hear from a resource witness on this? We have Crystal Left-Pinion from Indigent Defense Commission, if there's no questions for her. Mr. Allison, do you want to testify or just here as a resource? We'd love to hear from you if you want to testify, but nobody has questions for you. Any questions for Mr. Allison? Very good. We got you for the bill. Thank you. And we do have, wishing to testify, Ellen Bowman.
Well, Mr. Chairman, there is a committee substitute.
Thank you. The chair lays out the committee substitute and recognizes Senator Zaffarini to explain the substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, the committee substitute differs from the bill as filed in that it would provide services to an indigent parent or child during a DFPS investigation and require only the local administrative district judge in each county, rather than each district and each county court at law judge, to report rules, fee schedules, and other information about compliance with the defense provided by the county. So it just streamlines it.
Very good. Thank you, Senator. Any question for Senator Zaffarini on the substitute? Very well. We'll open public testimony, and the chair calls Ellen Bowman, or Bauman, B-A-U-M-A-N. Ellen Bauman for the bill, wishing to testify. And if there's anyone else wishing to testify on, for, or against Senate Bill 2120, please register at the kiosk outside. Please have a seat and make yourself comfortable. When you get situated there, you introduce yourself and give us your testimony.
I appreciate the opportunity to speak on behalf of families in the state of Texas who deal with these issues.
And tell us your name.
Ellen Bowman.
Go ahead.
I am a resident of Joshua, Texas, and I am the grandmother of a 30-year-old young woman who has intellectual disabilities and other other issues as well. And just would like to speak in behalf of, in the Fort Worth, Dallas area alone, we've had numerous incidents where children were removed and the families struggled and took months. And when you take a child with autism out of their home, out of their natural environment, and make things worse, and the family is not able to do anything about it because of the funds. And just as a side, we provide criminal defense attorneys for people who cannot afford an attorney, and I think this certainly warrants the access to legal representation as well. And thank you for considering this.
Thank you.
Thank you for your testimony. Let's see if anybody has any questions. Senators, any questions for Ms. Bowman? Thank you for being here.
Thank you.
Is there anyone else present wishing to testify on, for, or against Senate Bill 2120? Seeing none, public testimony is closed. Bill's left pending at this time.
1606. 1606. Thank you.
The chair lays out Senate Bill 1606, 1606, and recognizes its author, Senator Safrarini, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 1606 relates to evidence and orders regarding intellectual disability or mental condition in certain guardianship proceedings. Members, this bill would implement guardianship recommendations from the Governor's Committee on People with Disabilities. Guardianship should be only as restrictive as indicated by the person's actual mental or physical limitations and is necessary to promote and protect their well-being. Accordingly, it is important that all parties involved in the guardianship process be trained to help families select the best option for their family member with a disability. Relatedly, it is difficult to modify a guardianship and even more challenging for persons to get their rights completely restored. Generally, Senate Bill 1606 would require physicians or psychologists performing evaluations to establish guardianships to have experience examining persons with intellectual disabilities. It also would allow licensed psychologists, in addition to licensed physicians who are already authorized to do so, to offer evidence and restoration of rights or guardianship modification hearings for persons with intellectual and development disabilities, and would expand eligibility for restoration hearings to persons who are diagnosed with mental health conditions but have sufficient capacity with supports and services. There is a committee substitute, Mr. Chairman, and we're working on a new one to address some concerns, so perhaps we could send this one up and not adopt it and then substitute the new one when it's ready.
The chair lays out the committee substitute and recognizes the author to explain the first substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, the committee substitute was developed to address the concerns of several stakeholders, and generally it differs from the bill as filed in that it would clarify that a physician or psychologist who has treated the person and has an established patient-provider relationship with the individual has sufficient experience examining individuals with an intellectual disability. And again, we're working on a new one. Thank you.
Very good. Thank you, Senator. Members, any questions for the author? We'll open public testimony. And we have, as a resource, Lauren Kirkin here, Texas Council for Developmental Disabilities. Do we have any questions? Anybody need a resource witness? Very good. We'll open testimony, and a chair again calls Ellen Bowman, Jeff Miller, Ashley Ford. So again, Ellen Bowman, Jeff Miller, I see Mr. Miller, and Ashley Ford.
Since this was your party, you can.
Welcome. Welcome. We'll start over here. You know the routine. Introduce yourself, Jeff. Give us your testimony.
Jeff Miller, Disability Rights Texas, and we are for the bill. Good morning, and thank you for the opportunity to be here and testify about this bill. I am Jeff Miller. I do work for Disability Rights Texas. We are the designated protection and advocacy organization for Texas, and we are wholeheartedly in support of the changes in this bill. Thank you to Ron Lucy and the Governor's Committee for convening a work group last year emphasizing how important the issue of guardianship reform is in Texas. And thank you, Senator, for, again, supporting this issue, which we know is so dear to you. And which we have made so much progress in. The work group that was put together by the Governor's Committee was a diverse group from people around the state in all different roles, from advocates to attorneys to judges that practice these things. And we tried to come up with some ideas of what were some basic, simple things that could be done to address the most pressing issues. And one of the most important things that this group agreed upon was that because so much emphasis is put on the medical evaluation that's used in establishing a guardianship and in trying to restore someone's rights, it was so important that the medical professional conducting that evaluation be the right kind of medical professional. And so we really thought specifically, number one, if we are talking about someone that has an intellectual disability, that a psychologist should be included in providing evidence around capacity for restoration's sake. So that's one of the changes that's made in the bill. One of the other things that was really important to the work group was that there be some kind of awareness, whoever the medical professional is, on intellectual disability, if that was the basis. And so that change requiring someone to have knowledge of intellectual disability we thought was very important.
Thanks for your testimony.
Yes.
Welcome back. Introduce yourself. Give us your testimony.
Thank you. Ellen Bowman. I represent my granddaughter and my family, as well as the ARC of the DFW area. And I'm very much in support of this bill. Some of you may know I am on the Governor's Committee for People with Disabilities and did chair this work group, but I am speaking personally today. This is an issue that is very dear to my heart because of people I'm close to who were placed under guardianship that should not have been, and fortunately with the help of different organizations, we were able to get that reversed, but it is not an easy thing to happen. I think creating awareness is something that's very important as far as the steps families need to take, and they need to be aware of also the court system as well, to make sure that our county judges, who so often are the probate court in the remote areas, and we have to make sure that they are up to speed on the alternatives to guardianship, and also on the issue with the appropriate CME. So I ask that you all consider this in a positive light, and I appreciate each of you being here today and the opportunity to talk to you about this. And thank you, Senator, for bringing this to this point.
My pleasure.
Appreciate it.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good morning. My name is Ashley Ford. I'm the Director of Public Policy and Advocacy for the ARC of Texas. The ARC of Texas promotes and advocates for the human rights and self-determination of persons with intellectual and developmental disabilities. The ARC wholeheartedly supports this bill. It is a common sense bill. If we are, guardianship is very serious business, and whenever we are considering, removing someone's civil rights, we should absolutely ensure that the folks that are making those recommendations have the proper credentials to do so. So I appreciate this committee hearing this bill today, and thank you, Senator Zaffarini, for filing this bill. Thank you.
Thank you for your testimony. Senators, any questions for the witnesses? Mr. Miller, Ms. Bowman, Ms. Ford, thank you each for being here. Thanks for your testimony.
Thank you.
Is there anyone else present wishing to testify on, for, or against Senate Bill 1606? Okay, come on down. Come on down. Take your time. Take your time. Get situated there. We'll wait for you. You're fine. You're doing great.
Okay. Hi, Belinda Carlton. I coordinate the Guardianship Reform and Supported Decision-Making Task Force.
Okay, hold on 1 second. Let me see. Do we have?
I signed a card out front, or electronically.
Okay. Sometimes the software doesn't catch up. Will you do me a favor, Ms. Carlton? Of course, we want to hear your testimony. After you testify, will you get with Ms. Babb at the table and just fill out a paper card?
Absolutely.
Thank you so much. Welcome. Introduce yourself. Begin your testimony.
Okay, Belinda Carlton, the Guardianship Reform and Supported Decision-Making Task Force, and always appreciate Senator Zaffarina, your efforts on guardianship reform. We are for the bill with the exception of 2 words, which we would like to have replaced, and that is on, let me follow, Section 3, 2E, which states how or in what manner the ward's ability to make or communicate reasonable decisions concerning himself or herself is affected by the ward's mental health. We'd like to change that word to diagnosis, because mental health is episodic. You're not, you can't make a decision about whether a person needs guardianship because they have a diagnosis of bipolar, which I have, which my daughter has, my sister has, but we're all productive members of society, and I think my husband says I don't need a guardian quite yet, but anyway, that's the only thing. If we could change those 2 words, mental health, to replace it with diagnosis. And that concludes my testimony, and thank you so much for your work.
Thank you for your testimony. Senators, any questions? Thank you for being here.
Okay.
Yes, ma'am. Is there anyone else present wishing to testify on, for, or against Senate Bill 1606? Hearing none, public testimonies. Oh, hang on, we have very good. Take your time. Take your time. Come on down.
No.
I wonder if he's in her.
Hello.
Apologies, I got 3 hearings going on today. Hi, my name is Lauren Gokin. I am a public policy analyst with the Texas Council for Developmental Disabilities, and I am on the bill. We appreciate the efforts in looking at guardianship. I had the pleasure of sitting on the Governor's Committee and People with Disabilities Guardianship Work Group, where we worked on and developed the recommendation to improve medical professionals who are involved in medical determinations for incapacity to help support that guardianship process. The only recommendation that we would make in the bill, and in the first section, it talks about having a medical professional or psychologist with experience with functional IDD for that creation process in guardianship. We would recommend that that language be added to the second section, where it discusses modification or repealing the guardianship process, so that if modifications are made, they're made with the support of a medical professional who has expertise in IDD, so that modifications really meet the development and needs of that individual. Thank you so much for having to take any questions.
Thank you for your testimony. Members, any questions? Thank you for serving on the task force. Thank you for being here.
Absolutely.
And will you do us a favor? Will you check with Ms. Babb and make sure we have your information correct on a card? Sometimes the software doesn't always pick it up.
Yeah, absolutely. Thank you.
Thank you for being here. Is there anyone else present wishing to testify on, for, or against Senate Bill 1606? Very good. Seeing and hearing none, public testimony is closed. The bill is left pending at this time. The chair now lays out Senate Bill 1624, and recognizes its author, Senator Zaffarini, to explain the measure. Senator.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 1624 relates to guardianships, alternatives to guardianship, and supports and services for persons with incapacities. Members, despite current law's requirement to appoint attorneys ad litem for restoration of rights proceedings, persons may not receive adequate representation due to biases, lack of training, and limited knowledge of less restrictive alternatives. What's more, although the courts are required to review guardianships annually, these reviews often occur inconsistently, leaving persons with little recourse to regain their rights or report abuse or issues with the guardians or guardianships. When these mechanisms fail, persons with guardians are left with limited options for recourse. Senate Bill 1624 would increase transparency and accountability in the guardianship system and improve the opportunities for persons under guardianship to have their expressed wishes heard and respected. Generally, then, Senate Bill 1624 would help ensure that attorneys ad litem represent the expressed wishes and interests of a person proposed for guardianship, allow persons proposed for guardianship or with a guardian to at any time retain attorneys to represent their expressed wishes in guardianship proceedings, including proceedings involving the restoration of rights or modifications to the guardianship, require the court to hold a hearing regarding the person's capacity to hire an attorney, protect the person with a guardian's right to private communication with physicians or other medical professionals unless there is a risk of substantial harm to the person or to others, direct probate courts to review reports prepared by a court investigator, a guardian ad litem, or court visitor, require the court investigator or guardian ad litem to prepare an additional report every 3 years, and specify the types of evidence about a person's capacity that may be admitted during a guardianship termination hearing. Mr. Chairman, we're working on a committee substitute, and it is not ready at this time. But we are working on things such as removing the consideration of appropriate supports and services from the definition of an incapacitated person, putting the burden of proof on the proposed person for guardianship to prove that person's capacity to retain independent legal counsel, and placing limitations on the extent to which a person under guardianship may have private communications with his or her physician. There were several concerns, and we're trying to address all of the concerns before we lay out a committee substitute. We think that'll save the committee a lot of time.
Thank you, Senator. Members, any questions for the author? Very good. We'll open public testimony, and we have two witnesses who have registered to testify. The chair calls Ellen Bowman and Taft Robinson. The chair calls Ellen Bowman and Taft Robinson for Senate Bill 1624. And those are the only two witnesses we have registered. So if there's anyone present wishing to testify on, for, or against Senate Bill 1624, 1624, please register at the kiosk outside or with Ms. Babb. Okay. Very good. Come on down, make yourself at home. We'll get started, and you'll be ready by the time we get down there. Take your time. Ms. Bowman, welcome back. Introduce yourself again. Give us your testimony.
Thank you so much for the opportunity to address the committee. This is a very, very important issue. We have countless people who are under guardianship currently that could function in life very well without guardianship, especially with the implementation of supported decision-making in Texas. And there's much to be corrected. We don't always consider, it's been my experience that we don't always consider the person who's coming under guardianship and their wishes, and I appreciate seeing this come to create awareness about those issues and give them the opportunity to go through life with someone who advises them and supports them in their decisions. All of us in this room have people that we consult with on our decisions, and this is not that uncommon. And we all deserve the opportunity to experience life, make mistakes, and learn from those mistakes. Ray Kroc, the gentleman who started McDonald's, he failed his way to the top. That's what he says in his book. And everybody deserves that opportunity. And thank you so much for considering this.
Yeah, thanks for your testimony. Welcome. Introduce yourself. Give us your testimony.
Hi, good morning. Thank you, Chair. Thank you, members. My name is Taft Robinson, and I'm a staff attorney with Disability Rights Texas, the Federal Protection and Advocacy Group. I currently work as an attorney who helps individuals with disabilities prevent guardianship and get their rights restored if they are currently in guardianship. Many times, individuals with, that are under guardianship tell me that the attorney they had that put them under guardianship didn't get to talk with them, they didn't get to speak in court, that person didn't advocate for them, and so they would have liked to have had the opportunity to have an attorney. Additionally, once they're in guardianship, it's really hard for them to get an attorney because they don't have access to money. They don't have access to a doctor who's going to support them. They're forced to see the doctor who their guardian wants them to see or their provider that they live with. Many times they don't get the opportunity to be in an environment where they're able to speak with people outside of the home. Many times their communication is restricted, so they're unable to speak with doctors, attorneys, anyone of that sort. So it's really important that they have the opportunity to speak with someone outside of their home, like a court investigator, a court visitor, on a regular basis, not just when they're able to reach out. They need to have someone who comes to check on them, because those people who their communication is restricted, they're the people that are at most risk, and so there needs to be a routine check by courts. And I do understand that that does cost additional money, but we're talking about individuals with disabilities who are being isolated from everyone around them. They don't have the opportunity if a court investigator or a court visitor or an attorney ad litem goes into that home. Thank you.
And thank you for your testimony. Welcome back. Introduce yourself again. Give us your testimony.
Hi, Belinda Carlton with the Guardianship Reform and Supported Decision Making Network. This is Senate Bill 1624 is a really good bill. It's going to advance the ability of people with disabilities to use services and supports rather than be placed into guardianship without any kind of due process. I have a quick story, if I may, which speaks to what Ms. Taft was talking about. Is my grandson, and I am furious, was placed under guardianship. He is now 23 and has autism. He did not have any due process. A social worker came out to my son's home and watched him swing on a swing, and that was it, and then went to the court with the recommendation that he be placed under guardianship. Now, this is at 18, before he's had any opportunity to exercise his civil rights and liberties, to live a self-determined life, and he is not living a self-determined life. In fact, their plan is to buy another house with a little house behind it and let him live there. So, that just doesn't work, and we must continue Senator Zaffarini's work to make sure that every individual has their civil right and opportunity. And I'm definitely for this bill. I just have one concern, and that is let's see, let me get back to the section. I'm sorry. Bear with me for a second. I think it was section 3, 5, let's see. Anyway, what it reads is, supports and services the ward has received as described by subsection D. 5, a description of the ward's activities during the past year, including recreational, educational, social, occupation, or a statement that no activities were available or that the ward was unable or refused to participate in activities. Well, an individual has the right to not participate and refuse to participate. So I would like to see that language struck. If we're trying to restore self-determination, then let's go all the way with it. Thank you.
Thank you for your testimony. Senator, if there's any questions for any of our witnesses? Ms. Bowman, Ms. Robinson, Ms. Carlton, thank you each. And Ms. Carlton, again, will you fill out a paper card for us? For some reason, it's just not picking up here when you registered outside. Thank you each for being here. Is there anyone else present wishing to testify on, for, or against Senate Bill 1624? Seeing none, public testimony is closed. Bills left pending at this time.
Thank you, Mr. Chairman, members, and thank you for your courtesy. I do have to get back to B and C, so I'd like to thank Senator Blanco for his courtesy, too, in waiting for my bills.
Thank you, Senator. And at this time, the chair lays out Senate Bill 1131. Senate Bill 1131, and recognizes its author, Senator Blanco, to explain the measure.
Thank you, Mr. Chairman, members, for allowing me to lay out Senate Bill 1131. This is a local bill that was requested by our largest school district in El Paso County. Currently, the El Paso Independent School District holds its school board elections in May, while the City of El Paso elections are held in November. The difference in the election dates prevents the sharing of election expenses between EPISD and the City of El Paso, which creates high costs, as you know, for the school district, that takes away from opportunities to address funding issues centered around educational needs with the district. So this is bracketed just to El Paso County to give the independent school districts that do not currently hold their school board elections the same day as a November uniform election, and it gives them an option to change the election date from May to November.
Thanks, Senator. Members, any questions for the author? Very good. We'll open a public testimony, and the chair calls Ed Johnson. Ed Johnson. He is shown to be for Senate Bill 1131. Don't see Mr. Johnson, but we'll his position's in the record. Is there anyone else present wishing to testify on, for, or against Senate Bill 1131? Seeing none, public testimony is closed. Bills left pending at this time.
Thank you, sir.
And the chair now lays out Senate Bill 2258, and recognizes its author, Senator Blanco, to explain the measure.
Thank you, Mr. Chairman, members. SB 258 is a local bill requested by the City of Fort Stockton to align their uniform election dates. Currently, the City of Fort Stockton holds two elections, one in May for the mayor and council, and the other one for judges and other city officials in November. Fort Stockton is a small rural town with a population that covers an area of less than 4,800 square miles. So it incurs the cost. It's about $8,000. $16,000 to hold two elections. So we're trying to reduce the cost for the City of Fort Stockton. It would give them the ability to change its May election to a uniform election date in November. And with that, I'll answer any questions.
Thank you, Senator. Members, any questions for Senator Blanco? We'll open public testimony and ask if there's anyone present wishing to testify on Senate Bill 2258. Anyone wishing to testify on, for, or against? Seeing none, public testimony is closed. Bills left pending at this time.
Thank you, Mr. Chairman, members.
Good to have you, Senator.
Likewise.
The chair now lays out Senate Bill 1780, and recognizes Senator Paxton to explain the measure on behalf of its author.
Thank you, Mr. Chairman and members. And I'm honored to lay this bill out on behalf of Senator Parker. In 2019, the 85th Texas Legislature enacted legislation to allow for remote online notarization, or RON, with several safeguards in place, including identity proofing and credential analysis. RON allows for individuals to have their documents remotely notarized, avoiding many of the inconveniences and potential difficulties formerly caused by the requirement that acknowledgments be witnessed by the notary and the signer within each other's physical presence. Transactions utilizing RON have proven popular and a great benefit to consumers. The current RON statute does not accommodate the use of a remote ink notary, or RIN. A remote ink notarization allows a person to use a wet ink signature rather than an electronic signature. Rather than digitally signing a document, the individual physically signs the document while supervised on a video chat with a notary. During the COVID pandemic, the governor provided for temporary accommodation in the form of a governor's proclamation that allowed for RIN in real property transactions if certain conditions were met. This was a helpful accommodations that allowed individuals to close real estate transactions during the pandemic when physical proximity created a lot of uncertainty. A straightforward means of providing for REN transactions going forward is to amend the existing RON statute to allow for REN while keeping the security framework for electronic notarizations in place. The committee sub for Senate Bill 1780 provides for a REN remote ink notarizations within the existing RON statutory framework.
Yeah, the chair lays out the committee substitute. Explain to us. And members, any questions for Senator Paxton on the substitute?
There's a little bit of description on the substitute. The committee sub provides for more specific statutory cross-references, provides clear compliance and reliance language to increase certainty related to a transaction, and creates a longer implementation period to allow the Secretary of State's office more time for any necessary rulemaking, and that's the committee sub.
Very good. Any questions for Senator Paxton on behalf of the author? Very well, we'll open testimony, and the chair calls Tim Morstad, John Fleming, Steve Streif. Tim Morstad, John Fleming, Steve Streif. You guys take your time and get any one of those seats that look good to you. And these are the three witnesses that we have wishing to testify, invited on the bill. If anyone else wishes to testify on, for, or against Senate Bill 1780, please make your way outside to the kiosk or check with Ms. Babb at the desk, and she'll have a paper card for you. So, gentlemen, welcome each of you. I'm going to start over here. I think, Council, introduce yourself, give us your testimony.
Thank you, Mr. Chairman and members. John Fleming, Texas Mortgage Bankers Association. We had the privilege of working with then Representative Parker to develop the RON bill for Texas, which has now been the model for at least 26 states, and other states have borrowed principles from it. We do think that that was designed for electronic transactions. During the pandemic, as you've heard, there was a hybrid model to use. We believe that the changes that are made maintains the protections of a remote online notary for this hybrid process. We have heard a couple of questions asked about the fraud aspect. I would suggest to you that as a practicing real estate lawyer for over 40 years, there's plenty of fraud going on in the traditional notary system. I've seen that, had cases on that. I think any remote online notary process, whether a wedding, signature, or electronic document, provides greater security because of the required video recording and the identity proofing that goes on with it. Happy to take questions.
Thanks for your testimony. Welcome. Introduce yourself. Go ahead.
Mr. Chairman, good morning. My name is Tim Morstad with AARP here in support of Senate Bill 1780 by Senator Parker. AARP supports this bill because too many Texans do not have advanced care or estate planning documents in place. SB 1780 will make it easier for Texans to get these important documents completed, especially those with mobility challenges. We already have, as Senator Paxton laid it out, we already have some experience with remote ink notarization. It was allowed during the pandemic. Senate Bill 1780 builds on that experience and is further based on model language by the Uniform Law Commission. It's been developed, it's been vetted, it's been in place for several years. So AARP commends Senator Parker for bringing this bill and asks for your favorable consideration.
Thanks for your testimony. Good morning. Welcome. Welcome back. Introduce yourself. Give us your testimony.
Thank you. I'm Steve Streif, and I'm Legislative Chair for the Texas Land Title Association. I'm here to testify in support of this bill. I think there was an excellent job by Senator Paxton of laying it out, and I agree with many of the comments made by Mr. Fleming regarding the security processes. Key factors for us is the identity proofing, the credential analysis, and the retention of the recording. And we think that this bill fits a nice niche It allows people that have the need for a wedding signature to be able to have the option of doing that remotely. Happy to answer any questions.
Thanks for your testimony. Senators, any questions for our witnesses? Mr. Strive, Mr. Morstead, Mr. Fleming, thank you each for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 1780? Seeing none, public testimony is closed. Well, let me be precise. I'm going to go ahead and use the magic words. That was an invited testimony, so we'll open public testimony, and we'll ask, is anyone present wishing to testify on, for, or against Senate Bill 1780? Seeing and hearing none, public testimony is closed, and the bill is left pending at this time. If there's no other business to come before the Senate Committee on State Affairs, the Senate Committee on State Affairs stands in recess, subject to the call of the chair. Good morning.